Tonight we are delighted to have a discussion called Supreme Control, the New Activist Court.
As I'm sure you all know, the court-packing fight is not Franklin Roosevelt at his finest. So I had a moment's pause before I thought about speaking ill of Franklin Roosevelt in the Harvard Club. And then I remembered some of the things that I read that they said about Roosevelt at Harvard in the 1930s, and I figured I'm probably safe to say whatever I might say tonight. I'll just say a few words as we kick this off. As I've gone around over the last year talking about Roosevelt, the court fight, and the lessons that it might have for us in this moment, and the clash that we're seeing now between a progressive president and a conservative Supreme Court or a conservative judiciary, I think what I've seen frequently is a tendency to overread the lessons of history. I'm probably supposed to tell you that the parallels are perfect. But actually, I think there are a couple of different ways to look at the court fight and its relevance now. It's easy to look at it and conclude that what happened in the 1930s, what happened in 1937 in the switch in time that saved 9, was that the court simply caved to popular pressure. And that's actually a reasonable conclusion in a lot of ways, and that's the story I try to tell in the book. But I think that it's too easy to simply suggest that if you put enough heat on the court, that the court will flip. I think that what people miss about that moment in history, and maybe want to think about in this moment in history, is that it took an awful lot of pressure on the court for an awfully long time before you saw the possibility of the court flipping. The clash between the Supreme Court and the New Deal was played out in banner headlines like World War II headlines for years before the court finally began to uphold New Deal programs. The pressure on the court from the left and to some extent the center, and the support for the court on the right were intense during those years as the court knocked down the NRA, knocked down the AAA, and seemed to jeopardize Social Security and a whole range of other New Deal reforms. And so the court, as Roosevelt said at the time, found itself very far out on a limb before the court wound up flipping in 1937. So I think that when we think about, and I'm sure we'll talk about this here tonight, when we think about healthcare, when we think of some of the other progressive reforms that are either in front of this court now or will come before the court over the next couple of years, I think it is worth remembering that conditions have to get pretty extreme before the court would even consider bowing, you know, I'm not sure they would ever describe it that way, but bowing to popular pressure.
Okay, and now I'd like to turn to Jeff.
Well, I'd just like to say that I am here because I'm happy, for many reasons, but mostly because I am evangelical in my admiration for Jeff's book. I mean, this is really history at its best. It is significant, but it is just an interesting tale with wonderful characters and unexpected deaths, and it's a fascinating work which I insist you all read.
A lot better than the 9, really.
Well, it's different. It's the old 9, but I guess I just make 2 points. I mean, one is that the story of how the court-packing plan rose and fell and how the New Deal came to be supported is in part, as Jeff tells it, the story of Justice Roberts' agonies and changes of mind. But ultimately, what it's really about is Franklin Roosevelt getting re-elected and winning long enough to appoint different justices. I mean, the idea that justices change their minds because of public opinion, because of really good lawyering, because of anything, is to me largely counterfactual. These people are who they are. They believe what they believe, and that by and large doesn't change. And the second point I would make is that the court is a very good barometer of our contemporary politics. And if you look who gets elected president, by and large, their views are replicated in the justices they appoint. A point to keep in mind, the last 3 justices to resign from the court, O'Connor, Stevens, and Souter, very interesting people, very different. You have this wonderful historic Arizona Paul, you have this reclusive New Hampshire bachelor, you have this sort of avuncular antitrust lawyer from Chicago. They had one thing in common. They were all Republicans. And they all became completely alienated by the modern Republican Party. The Supreme Court today is a very good reflection of the legislative branch and the executive branch, completely polarized between conservative Republicans and relatively liberal Democrats, with the eccentric and sometimes incomprehensible views of Anthony Kennedy deciding the outcome of all these cases. And it is, that's the way it's going to be until one of them leaves. And if President Obama replaces Justice Scalia, we're going to have one kind of Supreme Court. If President Palin replaces Justice Ginsburg, we're going to have a different kind of Supreme Court. And frankly, that's really all you need to know. Who wins the presidential elections, and then everything else at the Supreme Court is basically just conversation.
So, because conversation can be fun.
Right, yes. I mean, it's an interesting conversation, don't get me wrong, but it's...
Because conversation can be fun, Nan, why don't you tell us about some of the things that Alliance for Justice is engaged in, what you think are some of the biggest fights in front of the court and the appeals court, and some of the work you're doing in it.
Okay, well, thank you for inviting me. It's a treat, and there are lots of old friends here. It's wonderful to see, and I too am a fan of Jeff's book. I have 3 short points to make if I can remember them. One is I'm really happy that we're talking about the courts, because there are about 850 judges, federal judges. I think about 850 federal judges. There are currently 120 vacancies. That's a lot of vacancies. So it's good to be talking about courts. It's good to be talking about judges, given the incredible influence they have on our lives. And finally, Chuck Schumer, your senator, has really become the champion on the Senate Judiciary Committee. So he needs all the help and bucking up he can get. Number 2, this court, as we've seen over the past couple years, particularly under the leadership of Chief Justice John Roberts, has a real propensity to rule in favor of big business. Just last term, 13 out of 16 cases in which the Chamber of Commerce was a party, the Chamber won. That's a really big win record. We saw what happened with Lilly Ledbetter. We saw what happened in the Exxon Valdez case, where 32,000 Native Alaskans, fishermen, small business owners, had their damages slashed by over 90% by the Supreme Court. March 29th, the Walmart case is going to be argued, involving 1.5 million women who have brought a class action against that corporation for low wages and lack of promotions. So there's a lot of attention being focused on the kind of corporate bent of this court, and it remains to be seen what the justices will do. And finally, along the lines of corporate court, there is now a raging controversy over the attendance by Justices Thomas and Scalia at an event in 2008 sponsored by the Koch brothers. This event was a political event in the sense that electoral issues were discussed. The agenda focused on whether or not the Koch brothers and their colleagues could turn out enough people to get rid of the Democrats and put Republicans in. If these two had been lower court judges, district court judges, court of appeals judges, they could never have attended such a conference that was political. We're pushing very hard for legislation that would apply the code of conduct to Supreme Court justices the way that is currently applied to lower court judges. So lots of stuff to talk about.
Great. Jeff, we were talking earlier about a progressive president and a conservative court. Can you compare the relationship between this progressive president and this conservative court and Roosevelt's relationship?
Well, I think the important thing to say about Roosevelt is that he understood, really even before he became president, that for him to succeed, for America to advance into, for him to lay a new sort of foundation of what he called economic rights, that it wasn't simply a matter of passing programs. It wasn't simply lining up the reforms that would ultimately become the New Deal and getting them through. He understood that there was going to need to be a new constitutional understanding to undergird these reforms. And he understood that it was going to require ultimately a significant change in the jurisprudence of the Supreme Court and the federal judiciary generally. And this was a court that had been a powerfully conservative force in American life for a half century, really. So Roosevelt had a strong understanding at the outset that the advance in social and economic legislation was going to have to be accompanied by, and ultimately, as I said, undergirded by, an advance in constitutional understanding as well. I think that if we move to the present moment, nothing like that is required. There is nothing in the Health Care Act, for example, that requires essentially a new jurisprudence to uphold it. That is not the argument that its supporters are making. Its supporters are making the argument that there are many decades worth of precedent that support exactly what it is that we're trying to do here. And so I think that the programs of the Obama administration and the kind of constitutional understanding that needs to accompany it are far less radical in their implications on both fronts than what it was that Roosevelt tried to do.
And Nan, you hosted a press conference the other day with Sheldon Whitehouse, who's on the Judiciary Committee, and in that press conference, he laid out a lot of cases where the Supreme Court had ruled in favor of corporations over small businesses and over individuals. I think some people, some more progressive-minded people would probably argue that the relationship between the corporation and the individual has a lot to do with their economic well-being. So the policies of the Obama administration aside, do you see a jurisprudence that is harmful to regular Americans' economic life?
Well, I see a Supreme Court that is, these days, with the current majority, together with many of the appellate courts around the country, as very dangerous to the rights of everyday Americans. And it's interesting because the president hasn't made the judiciary as yet a real priority. And yet, health care, maybe financial reform, will be cases that will eventually, I mean, we do know there are now, I think, 5 district court decisions on health care. Those will eventually wend their way up to the Supreme Court. So I do think that we could be on a, as you say, a little bit of a collision course with a president who was very ambitious his first 2 years in terms of his legislative enactments, maybe being curtailed a little bit by some of these judges and courts of appeal. It's interesting, I'll be the last thing I say, that one of the judges, the district court judges, that decided against his health care package, his health care law, was sitting in on a vacancy that had not yet been filled by this administration or by the Senate. So I do think at some point he and the White House might really feel some pressure on this to step up the pace and maybe speak to the nation about the importance of the courts and judges and what they do. It's been a White House that's been relatively quiet on this topic, and I'm thinking that as some of this stuff goes up there, he may in fact need to address this important subject.
I'd just like to say that, the conservative movement has been intellectually vibrant and successful in the legal world in the way that liberals have not. And if you look at the recent history about the big issues, whether it's gun control and the evolution and the meaning of the Second Amendment, which has been a long-term project of conservatives, whether it's the meaning of the First Amendment in terms of corporate speech, whether it's the shrinking of the Commerce Clause, the scope of federal power. These are all causes that conservatives have championed. The irony is that conservatives are the ones who always say, oh, we don't like a living constitution. They're the ones who've made much better use of a living constitution than liberals have. I mean, the judicial philosophy of Democrats and liberals on the Supreme Court has been sort of a finger in the dike. Don't overrule Roe v. Wade. That's not much of a rallying cry. I mean, there is not the intellectual ferment has all been on the right. And if I can just make an observation, I think the way not to revive the liberal movement is with phony baloney ethics controversies like Clarence Thomas going to some meeting. As far as I'm concerned, they should go to more meetings, not less. And I don't think he should recuse himself. I don't think he did anything wrong. I don't think that is an important issue at all. Clarence Thomas going to meetings with people he agrees with already is revealing, but it's not unlawful, it's not improper. And as far as I'm concerned, they should go to more meetings, not fewer of them, and be out in the world more, not less. Thank you for that ovation.
Would anybody want to offer a counter to Jeff's
Michael.
On that topic?
on that topic?
Yes.
Go ahead, Nan.
I was
Yes.
baiting you now.
Of course, Jeff. Well, I would argue with two things. One is respectfully.
That's not
Number
necessary.
one, I do think for perhaps people in this room and progressives around the country, I do think Citizens United was a tipping point. And I would say that up until that, I think progressives didn't make the court as much of a priority. But I think with Citizens United and the fact that the Supreme Court overreached, chose to overrule two Supreme Court precedents, could have decided the case on a very minor issue, limited issue, and chose to talk about First Amendment and rights of corporations and speech, I think was a huge power grab by the Supreme Court. And I do think it woke people up. And I do think there is passion for that. And I think depending on what happens with the Walmart case, it could drive some real energy. I will say that the first legislative act of Barack Obama was signing the bill overturning Lilly Ledbetter. And he didn't do it out of the goodness of his heart. He did it because men felt very strongly, passionately about how wrong that court was. So I think we're making some inroads. Two, on these ethics issues, I don't think they're unimportant. I don't think we ought to be asking justices to retroactively recuse themselves, but I do think it's important for judges to go to American Bar Association events, Federalist Society events, ACLU events. But I do think there's something improper about a judge or a justice going to an event where you are talking about political electoral issues. I do think there is a line, and I think it's an important line or distinction to draw. The other, I think, important issue, and we may disagree, I bet we do, is on the recusal issue. That is, if I could say a word about that. I'm not saying that Justice Thomas ought to recuse himself, God bless you, because his wife worked for 6 years for the Heritage Foundation, specifically in activities against the passage of health care reform. I'm not saying that Justice Thomas, needs to recuse himself, because spouses do all kinds of things. But I do think in the case of a Supreme Court justice that the final decision shouldn't be up to Justice Thomas. I think there are lots of options so that other justices on the court, the other 8, might weigh in as to whether he ought to recuse himself when the health care legislation gets to the Supreme Court. Maybe a retired Supreme Court justice ought to weigh in on a decision, but I don't think it should be up to Clarence Thomas exclusively to make the decision when he's asked to recuse himself in that health care case. The same way I thought it wrong that Justice Scalia would be the final decision maker when the Sierra Club asked him to recuse himself from deciding the appropriateness of the Cheney task force, when, remember, Cheney and Scalia went duck hunting during the pendency of that case. Again, I don't think it should be up to the Supreme Court justice whose own conduct is being called into question.
So you would certainly agree then that Elena Kagan, who worked in the Justice Department when healthcare reform was being passed, and when that department was giving legal opinions that it was constitutional, she should certainly recuse herself as well.
I
Get
certainly
out of
agree.
town. You don't believe
I
that.
certainly do.
What? You think
I'm
Elena
in town. I'm not
you
getting
should
out of
recuse
town.
herself in healthcare reform?
And
I
she
don't
has
believe that for a
recused herself,
second.
by the way, from 25 cases.
Yeah.
25 cases. Yes, I certainly do if she had a role in that,
don't.
Mr. Jeff.
I just want to jump in on a couple things. First, on Citizens United and public opinion. The question of the public's response to the Citizens United decision. Almost a year ago now, Alliance for Justice and Brennan Center and ACS hosted a panel up here in New York where we talked about these matters. And there was a lot of excitement on the left about a poll that appeared in the Washington Post shortly after the Citizens United decision that said 80% of the public opposed the decision. Even I think it was 76% of Republicans opposed the decision, even though the press coverage suggested that the benefits were mostly going to flow to the Republican Party, as has indeed been the case. And there was a lot of excitement at the time that that might galvanize the left, that dot might be connected to other pro-business dots and so forth, and that you would begin to see a movement against these sorts of decisions, against these sorts of judges, and so forth. And I guess where I disagree with you, Nan, is that I think it's been rather a disappointment in the year since. Despite those incredible numbers in that poll, I think what Republicans in Congress quickly assessed, what they quickly saw, was that feeling, while the numbers were big, wasn't particularly deep, that it didn't resonate particularly deeply for most Americans. And in the wake of that, you saw, I believe it was Senator Whitehouse and some others who tried to pass the Disclose Act, which really just tried to mitigate some of the worst effects of that decision, to suggest that these donors, while their donations might be unlimited, at least the groups would have to disclose who the donors were. And even in the wake of Citizens United, they weren't able to get that through Congress, despite the support of Democrats in Congress who were then in the majority, and despite the support of the president. So I saw a more recent poll that suggests that only 22% of the public today or recently is even aware of the Citizens United decision. And so I think a lot more of this sort of thing has to happen to really galvanize more than a small community on the left. So that's my first point. The second is really more of a question for all three of you who are a lot closer to these issues than I am, and that is, Jeff, to your point about why, even to this point, the intellectual ferment still seems to be predominantly on the right. I went last year to talk to some students up at Harvard who are members of ACS, and I found enormous frustration among this really talented group of students that legal thinkers on the left weren't offering better answers, and that judges on the left weren't offering better answers. That all they were being left with, Michael, to your point, was judicial restraint. And there's not a lot of sex appeal to judicial restraint. You don't man the barricades for judicial restraint. It was a rallying cry in the 1930s, as Michael said, and there was a lot of deep belief, and there was a lot of thinking that had been done on the part of Holmes and Brandeis and Cardozo and a lot of others that went into this. But what seems to be lacking now is an identity, is a jurisprudential identity on the left that can get these talented students at Harvard and other law schools excited about engaging on these issues, whether they do so as lawyers or in the political arena or ultimately as judges. And the question that no one's answered to my satisfaction over the past year is, why is this lacking on the left?
Well, and let's not kid ourselves. Liberals are for judicial restraint, except when the state legislature wants to restrict abortion. Then we're not so much for judicial restraint. And we're certainly not, you are certainly not, for judicial restraint when it comes to Proposition 8 in California. I mean, you know, that's why I think judicial restraint is, you know, it's not much of a slogan to rally around, because everybody's for it except for the times that they're against it. And that is and believe me, I am familiar with the arguments for, you know, why same-sex marriage should be constitutionally required and why the right to choose should be protected. But I mean, it is not judicial restraint to have the courts insist on those rights being vindicated. And I think it's also worth mentioning that we did have the Warren Court, which was an enormously liberal and an enormously successful revolution in American constitutional law that, you know, guaranteed equal rights for African Americans, and under Warren Burger basically extended that almost completely to women, and you know, guaranteed procedural due process, that the government couldn't take your welfare benefits away without a hearing. I mean, all of those victories were enormously important, and you know, there was, I think, a natural retrenchment after that. I mean, natural, I guess, when Ronald Reagan gets elected president, I suppose that's natural, but that it was unclear where to go from those victories. But I mean, let's not forget they were serious victories.
Just to follow up, I don't know if I'm agreeing with you or not, but
I don't know if I agree with you.
but I think there's a tension, and there's a lot of, by the way, A-list people here who know and studied all of this for many years as well. But I think there's a tension among progressives, and that is, Jeff, because of the Warren Court era and some of the amazing victories that came across, I think progressives still revere the courts as well as the Supreme Court. As Michael has said, there's the NAACP Legal Defense Fund, there's the ACLU, there's a whole host of organizations around the country. You take any executive director of any of those groups, and they'll be positive about the court. They'll say wonderful things about the courts being there to protect our rights and freedoms. On the other hand, if this room looked very different, if this were a room of the Koch brothers convention, I can tell you, the mood would be feisty. People would be angry at the Supreme Court. There would be people in that room who still resented Roe versus Wade, who still resented Brown versus Board of Education. Remember, Brown gave birth to a whole movement in this country. Remember, people in the South had bumper stickers saying, "Impeach Earl Warren." So if you got a group of ultra-conservatives together, they wouldn't be feeling cheerful about the court, even despite the Lilly Ledbetters and the Exxon Valdez's and the Gross case and the Citizens United. They'd be angry. And frankly, anger fuels politics, anger fuels action and passion, And I think that is a particular obstacle for progressives. We're still in a state where, and maybe appropriately so, we do revere the court, but I think it's changing. And I think with Citizens United marks the beginning of that change.
I want to.
Sorry, just a quick observation. I think in terms of painting the political context, there's a third group, smaller than the two that you just mentioned, that I think needs to be brought into the picture, and that is that I think that there are a good number of progressives who feel that as much as they revere the Warren Court and revere the victories of the Warren Court and are indebted to them, feel that the time for that sort of thinking has passed. And I think one of them is now President of the United States. He's been very clear over the years, before he became president and since he became president, that liberals have over-relied on the courts, and that we probably, he has said, should have fought some of these battles in the state legislatures, should have fought some of them out in the political arena, suggesting essentially that that's what we're going to have to do from here forward, that we can't count on the courts anymore, even now that he's president and has the appointive power. And so he is not looking in, and I know there's been some frustration on the left with some of his picks, not only for the Supreme Court, but for the appellate courts as well, that he's not picking justices and judges in the mold of a Thurgood Marshall or Brennan or others, but that he's picking more moderate judges who do not fashion themselves in the mold of the Warren-era justices. And so I think that, I don't know how big that particular constituency is that agrees with the president, but the president agrees with the president, and that's pretty important.
So I want to kick it open to questions. Erwin?
Wait till you get the microphone.
Or just holler loud and I'll repeat it.
Hello, hello. I think two of our speakers seem to be speaking past each other. One suggests that you change the Supreme Court by having them change their jurisprudence. The other one says you change the Supreme Court by changing the justices. And I just wonder, when you get back to Roosevelt, was it public pressure that changed the Supreme Court, or was it a change in personnel?
Well, I'll try to answer that question as quickly as I can. I think
Read Jeff's book.
that's even quicker than my answer was going to be. I think that the evidence suggests, we can never know for certain what caused Justice Roberts to flip in 1937, but I think the evidence suggests that it was not the court-packing plan itself, but it was the political environment. As Jeff said, the fact of Roosevelt's reelection, the fact of his reelection by a landslide, the overwhelming public reaction against the Supreme Court's decision in the Tapaldo case in the middle of 1930, at the end of the 35-36 term, in which the Supreme Court overturned a New York State minimum wage law that had been very carefully drawn to avoid Supreme Court challenge. There was a huge public reaction against that decision. And so when you look at how the political factors were lining up, it does seem that ultimately Roberts gave into that pressure. But I think at the same time, what Jeff said is exactly right, that the reason we call it the constitutional revolution, some of us, of 1937, is because the appointments that quickly followed enabled it to endure. In the fall, when the court reconvened in the fall of 1937, Hugo Black had replaced Willis Vandevanter, who had been one of the arch conservatives on the court. And then the liberal appointments followed in a very quick fashion after that. So the court was transformed along and then, yeah.
Well, if I can just offer a plug for another very good recent book, Noah Feldman's book, Scorpions, which traces the Roosevelt appointees to the court. And, you know, you had Hugo Black, you had Robert Jackson, you had Felix Frankfurter, and what's the fourth one he focuses on in that book? Douglas, of course. And, you know, they came to disagree with each other about a great many civil liberties and civil rights issues, but they never disagreed with each other on the reason they were all appointed to the court, which was the scope of federal power. And it was Roosevelt's 8 appointments to the court that really just took this issue off the table. And, you know, in 1995, there was the Lopez case where they sort of revived the Commerce Clause doctrine a little bit, but basically that went nowhere. I mean, this was essentially a dead letter the Commerce Clause. The idea that there was a substantial restriction on federal power to regulate an economic matter is something that when I went to law school in the mid-1980s was a historical curiosity. And now, I don't know if they're going to get 5 votes for health care reform.
You can just say it loud. I'll repeat it if the microphone can't get to you.
As the director of a film about the confirmation process, I'm quite interested to hear that nobody has mentioned the Senate, who allegedly, according to some, is a co-equal partner in the appointment of Supreme Court justices. And I wonder, A, whether anyone thinks that who we elect as senators is part of the strategy of changing the court, and B, whether any of you perceive that there's a way to get a more honest conversation, which might, for instance, allow a president who's progressive to appoint someone who says something more than, I believe, in judicial restraint.
Well, we may soon find out, because, I mean, the betting today is that we will have a Republican Senate in 2013 and a Barack Obama reelected, and you are going to likely see Supreme Court confirmation battles that will be quite intense, especially given the contemporary Republican Party. You know, my experience with judicial issues in a political context is that the people who decide elections, swing voters, don't care. And that's why presidential candidates almost never talk about it. The people who really want Roe v. Wade overturned, they're going to vote for the Republican anyway. The people who really want Roe v. Wade upheld, they're going to vote for the Democrat anyway. And the people in the middle, the people who decide the outcome, and I think this is true for senators as well as presidential elections, they just are not highly motivated by these issues, and frankly, I don't see that changing anytime soon.
Sadly enough, we do focus groups every 2 years with groups of 35 people around the courts, just to figure out, find out what people are thinking. And I can tell you, 2 questions are always asked at the beginning of a focus group. And you've got 35 people in a room, all voters. The first question is, how many justices are there on the Supreme Court? And I will tell you that no one, I've never been in a focus group where people know the answer to that question. And then we ask them, the second question, name someone, name a justice on the court. And again, if they're kind of our generation, they may remember Anita Hill and Clarence Thomas, so they'll say Clarence Thomas. But anyone younger doesn't know, cannot name. Maybe one person in the 35 can name. So as you can imagine, making this an issue around a Senate election, as hard as some of us have tried, is a very tall order. The odds are just stacked against you because so few people actually know about the courts. But what really comes through in these focus groups is that Americans don't think they're qualified to even have a view of the courts or what judges do. They don't think they're competent to even discuss the courts, even though once they hear how important courts are in their lives, it's still, they just feel insecure. So making this an issue is walking up a very tall mountain.
I just wonder about this effort of all these right-wing groups to change the law. I mean, the fact is Kennedy was against small corporate speech from the very beginning. He dissented in Austin and McConnell. So that Sandra Day O'Connor had just lasted another 3 years. She's still sitting around on courts of appeal. She's still working. If she had lasted another 3 years, we would not have Citizens United, despite all the efforts made by all these business groups. So it really relates to exactly who sits on the court, and a lot of this effort by these groups, right-wing groups, I don't know that it makes that much of a difference.
Clarence Thomas and William Brennan, neither one of them died until Bill Clinton was president. If they had hung on, think of the absence in our lives not knowing about the Clarence Thomas, Anita Hill hearing.
Well, she so much as said that she would have made a different decision. And the other interesting thing about O'Connor is she felt very regretful about her decision to step down. I think she felt that, or they knew that in Bush's second term, 2 probably would have to go, because 2 went and Clinton got 2, Bush Sr. got 2, but she felt very sad that she actually stepped down when she did, because she didn't realize that how sick Rehnquist was. Remember, she stepped down, Roberts was put up for her seat, and then Rehnquist died. And I think she felt a little bit angry over the fact that she didn't know how sick Rehnquist was. I think she probably wouldn't have stepped down.
Rick?
Apart from I'd like to ask both Jeffs this question, and anyone else who wants to take it. Apart from the fact that it failed, was there anything wrong with the court packing plan?
Well, I'll let the real expert answer first, but I think one of the fascinating things to me about Jeff's book was that what I had always assumed was this wild, eccentric, mad power grab on FDR's part. I mean, what I really learned from Jeff's book is that this was a relatively restrained step, because a lot of people wanted him to try to amend the Constitution, and he might have gotten that through. But you know, what a lot of people don't realize is that the number of justices is not set in the Constitution, and it has actually fluctuated over the years. And so he just attempted a temporary increase in the number of justices, which anyway, I just thought that was such a fascinating insight from your book. Now I'll let you talk about your book.
Well, thank you. This was a great surprise to me when I began my research, because I didn't know much more about it than I had read in the standard accounts. And it's always portrayed, or almost always portrayed, as this sort of mad power grab, an act of irrationality, an act of hubris, and so forth. And so I was surprised to find that Roosevelt spent more than 2 years, really he spent almost the entirety of his first term as president, very carefully examining all the options that were in front of him. And most of the seemingly viable options were, as Jeff said, constitutional amendments, which would have drastically unbalanced the balance of powers among the branches. One of the most popular suggestions, and there was a lot of momentum for this in the country, was to give Congress the ability by a 2/3 vote to override any decision of the Supreme Court, which would have made the Congress and not the Supreme Court the last word on all constitutional questions. So there were a lot of proposals like this out there, and fundamentally Roosevelt came back to the view that he'd held from the beginning, which was that there was nothing wrong with the Constitution, that there was nothing really in the Constitution that prevented us from establishing minimum wages for workers, maximum hours for workers, and the whole range of New Deal reforms, from Social Security to the AAA to the NRA and other things that had gone down. So Roosevelt felt the problem wasn't the Constitution, it was these aged justices on the court who were twisting the Constitution to get the results that they wanted. And so he came around to this idea, which had been tried many times, and sometimes successfully, in the 19th century. As many of you may know, the size of the Supreme Court went up and down over the course of the 19th century, usually for political reasons. It was as low as 5, it was as high as 10. And when Andrew Johnson became president, the court and one of the justices retired, the Congress eliminated that seat from the Supreme Court in 1866, and then they went ahead and, for good measure, eliminated the next seat pending the next retirement, just so that Johnson wouldn't get the chance to appoint anybody. So the size of the court had expanded and contracted for these reasons. So Roosevelt felt that he was reaching back to an established precedent. Now, that didn't mean that it was good politics. Even though it had been done before, it hadn't been done in over 70 years, and so it was forgotten. And not to filibuster myself, but But I'll just add quickly that one of the things that I found so interesting, again, that had surprised me in the course of my research and that I really wanted to bring forward in the book is that he almost got away with it. That we just assumed that the writing was on the wall from the very beginning, and indeed it was bungled from the very beginning in terms of its public presentation. But really, right down nearly to the very end of this 6-month fight, if Roosevelt had been willing to compromise at all, he could have gotten 4 justices added to the court instead of the 6 that he sought, and we would have a court of 13 today instead of 9. He came very, very close to, if he had just pulled the trigger on the compromise just a little bit earlier, then he would have succeeded, and it's unclear how history would judge that act.
Ellen?
I want to push back a little bit at Jeff Tubin's suggestion that somehow the vibrancy intellectually is on the right, that they stand for the First Amendment and corporate speech. First Amendment and corporate speech, guns and so forth, and that we stand for getting rid of Roe v. Wade. I mean, Jeff, in my lifetime, and my lifetime is a little longer than yours, as an adult looking at all this, and certainly as a woman, I've seen the equal protection revolution, strict scrutiny applied to discrimination on the basis of race and sex. These are vibrant vibrant intellectual and vibrant jurisprudence. It seems to me, you know, and I mean, it's now applied beyond just gender on the basis of race, on the basis of sexual orientation. I mean, I think we're losing and they're winning, but that isn't because we lack either moral or intellectual depth, certainly in those areas, but in many others that probably I'm not smart enough about law to think about. And I think you're being a little tougher, as often is the case, on progressives than on conservatives.
Well, let me just put it this way. I mean, just think about 2 issues. There was a great moment in the first argument of Citizens United, which was argued twice. And the Solicitor General, who was defending the law, was asked by Justice Kennedy, could this law be used to stop the publication of a 500-page book that 1 page of which said, vote for Smith? And the Solicitor General, Assistant Solicitor General, said, yes, it could. And there was sort of a hush in the courtroom. And so it was an argument, there was a free speech argument made on behalf of Citizens United. That you know, and a non-trivial argument. So it's not like these positions cut only one way. Think about another case. The parents involved, the Seattle and Louisville school integration cases, where Chief Justice Roberts, you know, talking about, you know, sending kids to school on the basis of their race, you know, and he said the way to stop discrimination is to stop discriminating on the basis of race. I mean, again, he used a concept that liberals identify with as a force to stop a race-conscious remedy. So, you know, a lot of these tools, they don't fall simply on one side or the other, and conservatives have gotten very good at using things like free speech and equal protection to argue for results that I don't think you'd agree with.
I wonder, Jeff Tubin had mentioned that it was wonderful for Clarence Thomas to go to meetings, but I'm wondering if a Supreme Court justice can be removed if it turns out that it's true that a Supreme Court justice withheld legal information, as in the case of apparently Clarence Thomas doing with regard to financial matters.
Do you all know what this gentleman's talking about? I think you're referring to the fact that on Clarence Thomas's financial disclosure form for 6 years, each judge and justice is asked whether or not their spouse is getting non-investment income, and if so, to check the box and put down the amount. For the 6 years that Clarence Thomas's spouse worked at the Heritage Foundation and earned over $130,000, he checked the box no and wrote down none. And it's clear that someone goes, oh, I can only assume that someone looks at the forms that these justices fill out, and someone might have brought to his attention that maybe there was a, shall we say, a discrepancy. But I think there are some who would like to bring the fact that he erroneously filled that form out for 6 years to the attention of the Justice Department. Let's just say we are not pushing that.
Can I just say,
I would just say.
also, that I consider this a personal failure on the part of myself as well as the others of us who cover the case, because it's very well known that Ginny Thomas worked at the Heritage Foundation. That wasn't any sort of secret. And I look at those forms casually every year, and I should have said, well, why doesn't he fill that out? And I never did, and I think it was the LA Times that finally called. But I mean, look, I don't know why he left this out. I think it was clearly a mistake, but it was not something that we caught either, which we should have.
Well, I do think it was he was concealing information. I don't think there's any question about that he was concealing it. The question is,
I'm not sure that's true.
what for 6
He
years?
was too busy watching porn, man, to check the right
yeah,
box.
sorry.
Fred's.
This is a question about how the media refers to judges. And my impression is that decades ago they used 3 words and now they use 7. The 3 words would be, and this is district courts and a court of appeals and Supreme Court. The 3 years, decades ago would have been 3 words, Judge John Jones. Now it is 7 words as if they are a single description. Judge Jones, appointed by President Clinton, appointed by President Reagan. So has that been a change? If so, does it matter?
I'll just give you one example from the early 1930s. Most of my examples come from the early 1930s. If you hadn't picked that up. Roosevelt in 1932, in the last weeks of the campaign against Hoover, was giving a speech in Baltimore. I actually opened the book with this, and he gives a speech which is mostly about other things, including prohibition. But he throws in a line that hadn't been scripted, and he says, let's remember that this party, the Republican Party, has had complete control of all 3 branches of government for, however many years it was. He said, and then he begins to list them, and he says, the presidency, going back to 1920, the Congress, and he said, and for good measure, the Supreme Court. And there was an eruption on the right that he had said the unsayable, which is that these justices were Republicans. And the protest was, well, as soon as the robe goes on, they are sanctified, essentially, and they are freed of their partisan political affiliation. And not everybody agreed with that. Roosevelt certainly didn't agree with that, but enough people agreed with it that there was carping commentary about it, not only on the right, but in the press and so forth, that it was inappropriate to suggest that just because Republican presidents had appointed them, that they maintained any allegiance at all to the Republican Party or Republican ideology. And that began to change as the justices were under more of a spotlight during that period, and their partisan behavior, or their ideological behavior anyway, became more and more pronounced in the public view. I don't know when the practice began, but it certainly wasn't the case in those days.
Fritz, what you describe is exactly what I do at every opportunity, whether it's on CNN, in the New Yorker, because I think it is useful information. I mean, Nan mentioned earlier, 5 lower court judges have ruled on healthcare reform. 3 have upheld it, 2 have struck it down. 3 Democratic appointees have upheld it, 2 Republican appointees have struck it down. A coincidence? I don't think so.
So
But-
I'm going to just take the moderator's license here, because we're going to need to wrap up in just a second. But you talked about the sanctified, the sanctity of the judge once he puts on his robe. And I think we've definitely seen in American political discourse that no other person in a position of such power has the distance from criticism that the judges enjoy, whether they're on the Supreme Court or on lower courts. There does seem to be a media distance and a public distance to criticize them personally. And so, Jeff, even in hearing you sort of seem to assume that Clarence Thomas made a mistake rather than your assumption being that it was something other than a mistake. And potentially, if someone was a presidential candidate or a state legislator, you might err on the other side of bias. And when we walk into, you know, an era where progressives haven't done the sort of legal work maybe that we could have done, and the court's going to make a lot of decisions, how much should we close that distance and start to go after the justices individually and personally in the same way that people go after legislators and other people they disagree with? Should they maintain the sanctity they currently have?
I mean, I don't think they have sanctity. I mean, I don't think you can make a general rule in response to that. I think, obviously, when it came to the Anita Hill hearings, I mean, we had essentially a criminal investigation of one of those two people was committing perjury up there. You know, people can draw their own conclusions about which one it was. But, you know, when it comes to their activities, frankly, I don't think anything I'd seen in my lifetime as a court journalist, you know, arises to the level of scandal. I mean, you know, I certainly thought Bush v. Gore was incorrectly decided, but I didn't think it was unlawful or corrupt.
I would say it's completely appropriate to criticize a judge. I think it's fair game, and I think we should, and no reason not to. But I do think there's a line, and I think attacks on judges, in my view, are just out of the question. But I do think it's important to be able to criticize and speak out when decisions come down that harm whomever. I think that's fair game. What we saw during the Clinton administration, though, I mean, I would say, every other month there would be a call for impeachment of this judge, that judge. Your own Harold Baer, remember that? Harold Baer went through a couple months where people were calling for his impeachment. That definitely is beyond the pale, I believe.
Okay, last question. What is the biggest case coming up in the next 6 months in front of the Supreme Court, and what should we watch for it in, Nan?
Well, I think the Walmart case being argued the end of March will be the most significant case on the court's agenda, and I think all eyes will be on
And you want to
that
just sum
argument.
it up for the group? Just
The
let them know.
case? This case involves a challenge to Walmart's hiring and promotion policies nationwide because the women have been relegated to the most low-paying jobs with the lowest salaries. The case, though, is about whether or not this action can be pursued as a class action. So it's not about the merits of this case, it's about whether individuals who work for a corporation can come together collectively and bring a class action against a corporation who they believe has been very harmful to their ability to be paid fairly and promoted fairly.
Jeff?
Well, I'm going to say the public financing case. And then I'm going to defer to the real experts on the panel.
Jeff?
I think those are interesting. I think there are two issues that probably won't come up this year, but will be up sooner rather than later, that are truly epic in their significance. And one is healthcare reform, because it's really going to be about the scope of federal power, and it's going to be about whether Barack Obama's administration is a success or a failure. And the other is same-sex marriage. I mean, the Supreme Court is desperate to avoid having to rule on same-sex marriage because the arguments in favor of same-sex marriage as a constitutional right are so good that they're going to have a hard time saying no. But they don't want to be in a position of Roe versus Wade, of preempting the political process, of when you have every state that has come up where this has been a vote, even in California, even in Maine, it's lost. And the Supreme Court liberals don't want to be in a position of telling every state in the union you're wrong. The problem is they are wrong. And this is a real tough issue for the court, and they are going to duck it as long as they can.
Great, y'all. Thank you so much for being here. We're going to leave the bar open for about 30 minutes, and I know they'll be happy to hang around and answer questions. And 1 week from today, type into your computer dailyagenda.com. The Agenda Project is launching a sort of what Variety.com is to the entertainment industry. Daily Agenda is to the progressive movement. So you can look on that site every day and see great reports and lawsuits filed by organizations like Alliance for Justice and great books like the ones written by a lot of the people up on this panel. So look there in about a week. We'll email you because we do love to email people to remind you. Thanks.